Charles Peckham here. Employers have long been able to have an employee's case of sexual assault dismissed under Texas law if the assaulted employee has also sued for sexual harassment, which is an act protected by the Texas Commission on Human Rights Act, or the TCHRA. For plaintiffs, that rule is changed if the employee only sues for the assault and not for harassment, and the assault is by a supervisor, not just a coworker. The Texas Supreme Court in the Steak and Shake case held, number one, where the gravamen of a plaintiff's claim is not harassment, but rather assault, the TCHRA harassment laws do not preempt a plaintiff's common law assault claim. And number two, because the gravamen of the plaintiff's complaint in that case was assault, Steak and Shake did not establish as a matter of law that the plaintiff's claim was preempted by the TCHRA. This means that not only does the administrative process and the filing of a charge required in sexual harassment claims normally have to be followed, not here, but that the claim for assault could continue. The decision was based on the specific facts of this case. The young employee assaulted by a supervisor did not claim that Steak and Shake was liable for fostering or tolerating a hostile work environment, which would be a TCHRA claim, but instead that on a single horrible occasion, her supervisor as a Steak and Shake vice principal, without warning and without prior incident, sexually assaulted her at a Steak and Shake restaurant. As the essence of the claim was assault, the case was allowed to proceed. This is a lesson for employers that they can be held liable for the assaults by supervisors, and should be a warning for employers to be careful to protect their employees from unscrupulous bosses. Peckham Martin represents young workers in their first employment situations and works to remedy the wrongs of their employers, who are bound to the acts of their supervisors and managers.